Hi, this is Bhumika Indulia and welcome to our new episode of SCC Online Weekly Rewind. In today's episode, I'll be giving a quick rewind of important rulings by Supreme Court and also some of the important pronouncements by High Courts and Foreign Courts. Watch the episode till the end. In today's top story, I have brought before you a case where it was claimed that Shivling was found at the complex of Gyanvapi Mosque in Varanasi. The bench further directed that while the Shivling must be protected, it shall not affect the right to offer Namaz and other religious observances. In a later order, considering the complexity of the issue, the Supreme Court has directed that the matter be transferred to a senior and experienced judicial officer of the Uttar Pradesh Higher Judicial Services. Hence, a district judge will now decide the matter on priority. In a big relief for AG Perarivalan, convicted for assassination of former Prime Minister Rajiv Gandhi, the Supreme Court has directed his release after being incarcerated for 32 years. Perarivalan, who was originally sentenced to death by Tada Court, got some relief in 2014 when the Supreme Court commuted a death sentence to life imprisonment. However, his petition under Article 161 remained pending before the governor for 2.5 years following the recommendation of the State Cabinet for remission of his sentence and continued to remain pending for over a year since the reference by the governor. This was the main reason that weighed in with the Supreme Court while ordering his release apart from other factors. Allowing the review petition in the 34-year-old road rage case involving cricketer turned politician Navjot Singh Sidhu that resulted into the death of one 65-year-old Gurnam Singh. The Supreme Court has imposed a sentence of 1 year rigorous imprisonment on Sidhu, in addition to the fine of ₹1,000 imposed in the order dated 15/5/2018. Observing that a disproportionately light punishment humiliates and frustrates a victim of crime, the court said that the hand can also be a weapon by itself when a 25-year-old man who was an international cricketer assaults a man more than twice his age and inflicts, and hence some aggravated culpability must be attached if the person suffers a grievous hurt or dies as a result thereof. The Supreme Court has answered 3 important questions pertaining to the Protection of Women from Domestic Violence Act 2005 and has expanded the scope of the Act by holding that even in the absence of domestic incident report, a magistrate is empowered to pass both interim as well as final order. The expression right to reside in the shared household would include not only actual residence but also constructive residence in the shared household. It is not necessary that at the time of filing of an application by an aggrieved person, the domestic relationship should be subsisting. To understand the technicalities of this judgment, read our full report on SCC Online blog. The Supreme Court has granted bail to Indrani Mukerjea, accused of murdering her daughter Sheena Bora over her live-in relationship with Indrani's stepson after noticing that even if 50% of the remaining witnesses are given up by the prosecution, the trial will not complete soon. The Supreme Court has also granted interim bail to Samajwadi Party leader Azam Khan in a case where main allegation against his of forging certificates. The court noticed that Azam Khan has already been granted bail in 87 cases and has only now been implicated in the case at hand after a period of 1 year and 7 months. Azam Khan has also been directed to file an application for regular bail before the competent court within a period of 2 weeks from the date of order. Moving on to the High Courts. While striking down the Delhi's government's Doorstep Ration delivery scheme, the Delhi High Court held that the same cannot be implemented and rolled out by the government of Delhi, since the Lieutenant Governor has expressed his difference of opinion. The court also observed that though it is not for the courts to either frame the policy of the government or evaluate its efficacy or question the wisdom of the government, However, that does not preclude the court from examining issues with regard to competence, legality, and constitutionality of the policy, or of any part thereof, if a challenge is raised to the same before the court. Read our full report on SCC Online blog. Expressing that the right of worship guaranteed under the Constitution to be respected by all concerned and devotees cannot be denied their right to worship under any circumstances. The Madras High Court held that every devotee has got a right to enter into the temple and worship Lord Sri Rajiv Perumal in the way he likes without affecting the rights of other devotees or worshippers and temple activities. The court also observed that the religious right guaranteed under the Constitution must be provided to all concerned, and discrimination or denial of religious practices at no circumstances be allowed by the courts. Read full report on SCC Online blog. The Bombay High Court observed that touching private parts and kissing on the lips of a minor would not constitute to be an offence under Section 377 of the Penal Code. Read our full story on SCC Online blog. Moving on to the foreign courts. In a matter revolving around the challenge to the constitutionality of Section 33 Clause 1 of the Criminal Code, which dealt with the unavailability of self-induced intoxication as a defense for criminal acts like assault, the Supreme Court of Canada held that Section 33 Clause 1 violates Section 7 of the Canadian Charter of Rights and Freedoms by allowing a conviction without proof of mens rea or proof of voluntariness. It also observed that Section 33 Clause 1 of the Criminal Code eliminates the defense of self-induced intoxication akin to automatism applied to violent offences. Section 33 Clause 1 does not create a new predicate act offence of self-induced extreme intoxication or a new criminal negligence offence. The accused faces the full stigma of conviction and the full brunt of punishment for the general intent offence. Parliament notified Member of Parliament Travelling and Daily Allowances Amendment Rules 2021. With immediate effect, the rules of the members is entitled to receive travelling allowances in respect of journey performed by air in any airlines are modified. With modification of Rule 3A Clause 5, a member shall submit self-attested travelling allowance to claim travelling allowance when the journey has been taken via airlines. The Joint Committee of Parliament issued Payment of Family Pension Submission of Document Rules 2021 in order to regulate the payment of daily and travelling allowance and pensions of members of Parliament. These rules will be immediately effective for the payments of family pension of the members. Thank you for watching the episode. Stay tuned to our next updates.